Good afternoon and welcome to the American Constitution Society's annual Supreme Court review. I'm Russ Feingold, the president of ACS, the nation's leading progressive legal network with nearly 200 student and lawyer chapters in almost every state and law school around the country. Through our diverse and rapidly growing nationwide network of progressive lawyers, law students, judges, scholars, advocates, and many others, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and realize the promise of equality for all. If you aren't already, I'd encourage you to become a member of ACS and to donate. Our work is more important now than ever, and we need your support. Go to acslaw.org where you can join, donate, and find more information about events like this one. Some very quick housekeeping notes before we begin. This afternoon's discussion is being recorded, and the recording will be available on ACS's website after today's program concludes. For those interested in CLE credit, information is available in the chat. Finally, there will be time during today's discussion for audience questions, and to submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat to ask your questions, as we will not be monitoring it, and your question then would not be put in the queue. If you are a member of the press, please include the name of your outlet at the beginning of your question or questions. With the close of its third term, under the 6-3 conservative supermajority, it has become more evident than ever that this Supreme Court is willing to serve the agenda of the conservative legal movement, even at the cost of its own legitimacy, as well as the stability of our federal government, the rights of the most vulnerable among us, and the very health of our democracy. At the behest of the conservative legal movement's most extreme elements, this court has risked creating in the office of the president an unaccountable autocrat through a far-reaching and ahistorical grant of presidential immunity, and made it more difficult to hold insurrectionists accountable or to keep them off the ballot. The court has also granted the most zealous opponents of federal agency action their long-standing wish for a substantially weakened administrative state by overturning the Chevron decision and replacing their own judgment for that of agency experts who are accountable within our political system. To be sure, in a few cases, the court chose not to throw the country over the brink to which its previous decisions had brought us. But simply maintaining a status quo of substantially weakened reproductive rights, or disingenuously denying the inevitable consequences of its extreme and unworkable Second Amendment precedents, can only provide a tempered measure of relief, certainly not a cause for celebration. We may not be so lucky the next time the court takes up one of those or so many other issues. The fact is that this court continues its project of undermining long-standing rights, dismantling the tools of the administrative state, and claiming as its own the final say on a broad swath of topics on which previous iterations that the court had shown restraint and a sense of judicial modesty that seems largely absent from this conservative supermajority. So, what happened this term? And what do the decisions the court handed down mean as we look toward the future? How will this term reverberate through the lower courts and the other branches of our government? And what legacy is this court choosing to leave? To help lead our august panel in just considering these and many other questions is our moderator, Mark Joseph Stern, senior writer for Slate and a longtime friend of the American Constitution Society. For more than a decade, Mark has covered this U.S. Supreme Court, federal appellate and district courts, and state and local courts. He regularly appears on the Slate Legal podcast, Amicus with Dahlia Lithwick, is a regular guest on MSNBC, The Majority Report with Sam Cedar, and many other media outlets. He is the author of American Justice 2019, The Robert Court Arrives, and is nationally recognized for his insightful and unvarnished analysis of the most high-profile Supreme Court cases and the most under-the-radar federal and state lower court cases, which, as we all know, often serve as bellwethers of what's to come. So it's now my pleasure to hand the reins over to Mark for what I know is going to be an excellent conversation. Mark?
Thank you so much, Senator Feingold. I really appreciate the kind words. I, in turn, have the honor to introduce our panel. But before we do, I have some important CLE information that many of you will need. To get CLE credit today, you'll need 2 codes. The first code is BEACH, that's BEACH, as in the sandy place where we'd probably all like to be right now. Again, that code is BEACH, and I will provide the second code later in the event. Now let me introduce our esteemed panel. So we have, starting with Greer Donley, a professor at University of Pittsburgh School of Law, covering the reproductive rights cases today. I note that because Greer regularly writes for Slate.com with some of her colleagues, David Cohen and Rachel Ray-Boucher, and it's really an honor to finally be able to chat with her rather than just read her brilliant and often devastating writing in our own pages. Next, we have Matthew Bodie, professor at the University of Minnesota Law School. Sabeel Rahman, a professor at Cornell Law School. Genevieve Lakier, a professor at the University of Chicago Law School. And last but certainly not least, Kathay Feng, vice president of programs at Common Cause. And all of you other panelists, I would love to see you in Slate.com sometime soon as well. Greer can tell you that it's a delight, and you get to reach a very broad audience of folks who probably don't know as much about the law as many of our listeners and attendees today. So let's begin. I feel like I have a lot of discretion here, much more discretion than federal agencies now have, to direct this conversation at the start. And I guess I'm going to begin not with federal agencies, but with a case that I think the senator alluded to, which is one where the Supreme Court didn't do something catastrophic, but that doesn't mean it was any kind of progressive victory. And it's the abortion cases, Alliance for Hippocratic Medicine and Moyle. Greer, you are our designated reproductive freedom talker. Do you want to kick us off with Moyle and AHM?
Sure. Well, first, I'm so happy to be here, especially with all these fantastic panelists. So thanks for inviting me. So yeah, the abortion cases this term, right? There was a bunch of a kind of hype about them, and they ended up being a little bit less impactful than we thought they might be. The first case, the Alliance for Hippocratic Medicine case versus the FDA, involved the first drug in a medication abortion called mifepristone, which is the only FDA-approved drug to terminate a pregnancy. So for those of you who don't know, I like to do just a tiny bit of level setting, right? That 2/3 of abortions in this country are now completed with medication. And in particular, after COVID, the FDA removed a pretty tough requirement that it had on it that forced people to pick up the drug in person. So this is known as a REMS, and we often call it the in-person dispensing requirement. That rule had a pretty dramatic impact on access to abortion without any medical benefit. So in 2022, a group of anti-abortion physicians and activists sued the FDA to argue that the drug should never have been approved. And if so, at the very least, the FDA should not have removed the in-person dispensing requirement, amongst other parts of the REMS. And you had Judge Kaczmarek, right, coming in and issuing a nationwide injunction, basically, that parroted back almost all the arguments that you saw in the plaintiff's complaint. The Fifth Circuit was slightly less radical. It didn't stay the original approval of the drug, but it did, stop some of the FDA's later actions that made it easier to access mifepristone. And so, if these kind of lower court opinions had, if the court had adopted them, we would have seen a really dramatic impact in access to abortion nationwide. So not just in red states, but in blue states too. The court here unanimously dismissed the case on standing grounds. And it's important to note that I think most people who know anything about the law thought this case was remarkably weak, both on substance and on the merits. And you really saw the court, all 9 justices, finding that the plaintiffs here lack standing. Why? Because they didn't have a personal stake. There was no evidence whatsoever that the plaintiffs had been forced to prescribe this medication that they found so objectionable. In fact, federal law actually protected them to make sure that they never had to do such a thing. The causation elements were too attenuated. And you saw the court that overturned Roe versus Wade basically saying, nope, we're not going this far. So in some sense, yes, people have been really worried about this case. Medication abortion, very impactful. But on the other end, and allowing the status quo to be maintained is important. On the other hand, there's a lot of things to kind of keep in mind with this case. First, you have states trying to intervene and kind of restart the lawsuit. They could have totally different standing arguments. So it's possible the case will come back. I'm really curious to hear about how the people talking about corner post and other administrative law cases, particularly because this case involves a challenge to a 2000 approval of the drug. And then, of course, if Trump wins, none of this matters, right? He can direct the FDA to do whatever he wants with Mifepristone. So that was the first abortion case. The second one involves, should I go on to the other one, Mark, or did you?
Go ahead. Let's get it on the table.
Okay. So this one is about emergency abortions, right? EMTALA is a federal law that's supposed to require emergency rooms to provide care for stabilizing treatment in medical emergencies. And the Biden administration argued that it preempted state law, right? So many people might not know that some states, 6, don't have any health exception. They only have a life exception in their abortion ban. So Biden administration was coming in and trying to say, well, EMTALA provides essentially a de facto health exception. I'm rarely surprised by the anti-abortion movement, but I was surprised here when they decided to go after this guidance document because the impact was small and it was on really sympathetic abortions. You saw immediately Texas sued Biden, and at the same time, Biden sued Idaho. This case was kind of poised for a circuit split when the Supreme Court decided to grant cert. A lot of people were perplexed as to why the Supreme Court intervened exactly when it did. And you see the court in this case dismissing as improvidently granted the cert petition, right? So you had 5 justices saying they shouldn't have granted cert in this case, that things have evolved. Justice Barrett wrote for Roberts and Kavanaugh saying that the parties had narrowed their positions, everything was evolving, and that they shouldn't have stepped in when they did. And so the case is basically going back down. So a lot of media attention focused on the fact that the district court injunction in Idaho is going back in place, which means that people in Idaho will be allowed to get these medically necessary abortions, or this very narrow subset of medically necessary abortions. But on the same time, because the court did not hear the merits, it also allowed the Fifth Circuit's opinion, which basically said EMTALA does not trump the state abortion laws to stand, meaning that in Texas and in other states in the Fifth Circuit, that pregnant people are not going to be protected by EMTALA. So states like Texas that don't have a health exception, we've seen the tragic consequences that have come from that. So again, the court is kind of kicking this case. Almost certainly they're going to have to come back to it at another point in time. A lot of people have said, including myself, that the court knew abortion was a very tricky issue for Republicans in the coming election. And in both cases there, you could see them as just saying, hey, we're not going to get involved right now. But they certainly didn't foreclose them, having the harshest anti-abortion perspective in the future. And so we'll kind of have to wait and see how those cases, if they come back, and how the court deals with them.
I have so many follow-up questions I'd like to ask, but I want to get more cases on the table first. We did just have a question in the Q&A that I think is worth noting, which was the vote count in these cases. So Alliance for Hippocratic Medicine was 9-0. You mentioned that the split in the EMTALA case was was different. You mentioned it was 5-4, which is correct. A lot of people got that wrong. Can you just briefly explain how the justices voted? Because I think the different factions are quite interesting.
Yeah, it's very interesting. Yeah, so you had Kagan and Sotomayor writing a concurrence, and then you had Barrett, Roberts, and Kavanaugh writing a concurrence. Then you had Justice Jackson writing on her own, saying that they should have decided the merits, and the merits would say that EMTALA preempts state abortion law. And then you had Alito, Gorsuch, and Thomas write a dissent, basically saying the court should have considered the merits, and EMTALA does not trump state abortion bans.
Thank you. Tabeel, let's turn to you. Greer already sort of tagged you in when she mentioned the intersection between the abortion pill case and the administrative law cases. Can you walk us through what the court did this year? Perhaps it would be easier to start with what the court didn't do, since we seem to have an entirely new administrative law of the United States after this June and July.
Yeah, thanks, Mark. And, it's a bit of gallows humor here, but, we're going to throw out most of the case book when I go into teaching admin law next this coming year. So I think what I want to direct folks' attention to is a set of cases. And actually, I think the big punchline is how they all interact, right? So one is the Looper-Bright case, which you may have heard about. This is a case that overrules Chevron deference. I'll talk a bit more about that in a second. The second case is the SEC Jarchese case, which is about enforcement powers. And the third case I want to mention is Corner Post, which is a case about when plaintiffs can bring suit when they are allegedly injured by a regulation. In each of these cases, you have a conservative majority, the 6-3 or 6-2 in Loper-Bright case, majority really adding a bunch of new ways that judges can essentially throw out rules that they don't like. So with Loper-Bright, we now have a regime where agencies are no longer granted Chevron deference. What that means is the courts are going to take as their own prerogative, in the first instance, the right to interpret what statutes mean and what powers agencies have as a result of those statutes, even when they're matters of pretty technical decision-making. So the court was very explicit that they don't see a rationale anymore to defer to agencies, to defer to agency expertise. Even if there's ambiguity, it's the court's job, according to this opinion, to interpret what the statute means. And what that does is it actually starts to unsettle a lot of regulatory policy, right? There's anyone who has tried to interpret statutes knows there's no such thing as a precise, crisp, clear statute. And there's 1,000,001 decisions agencies have to make all the time. So this Loper-Bright already by itself is a pretty big power grab for the courts and an explicit agenda item for the conservative legal movement for a while. This interacts, though, really critically with the Corner Post case, because what that opens up, and Greer alluded to this already, what that opens up is actually another loophole that any sufficiently well-resourced litigant will effectively be able to challenge any regulation they don't like, even if it's one that had been promulgated a long time ago. So in Corner Post, what the court said is that the time limit for when regulations can be challenged, that kicks in when the plaintiff has been harmed, not when the regulation was promulgated. So if you think about what this might mean, for a minute, let's say there's a rule you don't like, it's been on the books for a long time. All you'd have to do is find, say, a new company, or maybe you incorporate a new company. Now you have a new plaintiff that is newly injured by this longstanding regulation. Now you can bring a suit. And thanks to Loper-Bright, now you can bring a suit where there's no longer Chevron deference.
And it's worth pointing out that what you just described is exactly what happened in this case, right? These interest groups tried to bring a suit to challenge a debit card regulation. It got tossed out because of the statute of limitations. So they just grabbed a random store in North Dakota as a co-plaintiff. And the Supreme Court rewarded that by saying, yeah, there's now effectively no statute of limitations if you use this loophole.
Yeah, I'm so glad you raised that, Mark, because I think that's exactly right. And really in all of these cases, the drivers of the cases are plaintiffs who are, by and large, corporations who are trying to get rid of regulatory constraints on their ability to do whatever they want, whether it's in the climate context or in a consumer protection context. One last thing that I'll add here is on the Jarchese case, which is an SEC case. That's really about agency enforcement powers. And in some sense, the holding is a bit technical. It's if the agency is seeking civil damages, the court now held that that has to go first to a court and to a jury trial rather than through an administrative proceeding. That could be somewhat cabined, but when you think about it in context of the other two cases, if you're an agency, okay, normally you would make a rule. Now it's kind of hard to make a rule and expect that to stand up given the override of Chevron. So you might use your enforcement discretion. Well, okay, if you're going to use your enforcement discretion, now there's a lot of ambiguity about what enforcement tools you might actually be able to deploy. The Jarkissi case isn't as extreme as Loper Bright, but when you add it all up, it just creates a lot of options for opportunistic judges who have a political agenda to then pick and choose their doctrine even more than they could have before and mess with whatever agency policies they might dislike.
Thank you. That's terrifying, but a really important and helpful overview of that trilogy of cases. I'd like to bring in Matthew now. And I'd love for you to pivot to the labor cases so that we can sort of begin to see a little bit of the fallout here. Maybe you could start with what the cases Nabil described mean for the NLRB and tie that to the Starbucks decision, and then bring in Muldrow and Bissonnette, two of the other important labor law cases from this term.
Right. Yeah, I think the big headline is that the board has often had skepticism from courts, particularly starting in the 80s, I'd say, and really kind of picking up around 2000. And there's always been tensions, right, between a national agency and reviewing circuit courts who think that they are in a better position to determine what the law is, and the board sees itself as the centerpiece of national labor policy and thinks that it should be really the voice of what national labor policy is. So the big question for labor law folks is not these cases that Nabil was talking about. What is their immediate, ramifications? Although Chevron obviously has immediate ramifications for the board. I'll start with that. So the absence of Chevron, Loper Bright's RIP to the doctrine, essentially opens up even more scrutiny by courts about decisions that the board makes about what the NLRA means, what the National Labor Relations Act means. So I think you're going to see a lot of judges, circuit courts mainly, but in some circumstances when there's special relief, district courts might have a say in that as well, or enjoining a rule. If the board doesn't engage in rulemaking all that often, it's usually adjudicatory, but the extent that it does issue rules, a district court might very well join that, as has happened recently with the joint employment rule. This is going to open that up. I'll give each individual court more discretion to say, well, you know what, we think the board got it wrong on this particular area. Jarkissi is maybe more existential potentially because the board, unlike a lot of other agencies like the SEC, only operates in administrative courts, except for the injunctions, which I'll talk about in just a second with the Starbucks case. But the board cannot pursue actions in district court for unfair labor practices. Again, outside the injunctive scenario, which is supposed to be pre the board process, right? So the board would be unable to do its job. And there's no private right of action. So if my labor law rights were violated, I couldn't go to district court and sue, right? It would just, what would happen? It would go back to Congress to kind of remake labor law, and Lord only knows what would happen under those circumstances. Now, the reasoning I've seen is that Jarkissi is distinguishable on a number of grounds: private versus public right, the remedies being equitable versus damages, and so I think there might be a couple more steps that the court would have to take before the NLRB is, again, blown up administratively. And
you're not at all worried that the court would take those steps. You're perfectly sanguine that they'll keep their hands off the NLRB. That's what you're going to tell us now, right?
I was listening to the Jarkissi argument and I was like, oh my, because for a while I was like, yeah, okay, whatever. This you hear every so often, and then I'm listening, I'm like, Could I see an argument that they're private rights? You know, I mean, I think, again, most labor law folks would say they're public rights. Some people seem fairly confident in saying that, but again, could I see an argument? Yeah, I could see an argument. I wouldn't buy it, but you know, I can see the argument. And then remedies, there's the Thrive case that's getting a lot of attention where the general counsel board remedies, because they're mainly equitable in nature, they have never really been that truthful, right? They've been pretty weak. And the general counsel is saying, hey, we've got to amp this up to the extent that we're looking to make people whole. We have to look, you know, did they miss, you know, a house payment because they lost their job? That's, if we're going to put them back in the position they would have been in if they hadn't been fired illegally, we should include that, right? But some circuit courts are saying, oh, now you're kind of moving out of those equitable remedies that, you know, you're supposed to be focusing on. So yeah, it is possible. It is possible. And that's, so in some ways, the Chevron is, there's some question about to what extent courts have really afforded Chevron deference to the board in the first place, even though a lot of the, you know, really important Supreme Court cases from the 50s, 60s, and 70s all emphasize the board's role as kind of the centerpiece of labor policy.
So you're telling us it was already bad, and now we'll see how much worse it can get.
Yes, that's right.
On that particular note, do you want to talk about the Starbucks decision?
So the Starbucks was the one NLRA case, and in some ways, it's an interesting case that it ended up before the Supreme Court. It's a really important factual case. The Memphis seven Starbucks employees who were fired, who were put back to work by the injunction. And before the oral argument, Starbucks and the Starbucks Workers United union kind of came to this kind of framework agreement, and some people thought that the case might be dropped. I think Lisa Blatt somehow finagled her way to make sure she had that 50th argument and got a victory pretty easily, I think. So I don't know if that was part of the Starbucks framework agreement, but the oral argument there was very kind of very bland in some ways. The Chief Justice interjected at one point, like, this can be a short opinion, can it? And, you know, there are those, right? So in writing in Slate, Terry Gerstein and Jenny Hunter make the case that this is a damaging opinion for the board because it undercuts the board's ability to say what labor policy is, to kind of have the right to kind of pursue injunctive relief. 10J relief is very rare, usually between, I think the last few years actually been really low in the teens, but maximum of like 100 cases a year, right? We're not talking about massive litigation across the country, but it's a really important tool because it's the worst cases it's designed to impact, right? To get those workers back to work, right? The Memphis 7 fired in the midst of an organizing drive. We've got to get those people back in there so we can show that labor law rights are important and protected, right? There had been different standards. It makes sense for the court to say that there's a national standard because it's a federal statute. Not surprisingly, they chose the 4-factor test that's kind of more commonly used in preliminary injunctions. But Justice Jackson does have a very impassioned dissent, and you could hear this. She was the one person in some ways kind of fighting the boringness of the oral argument by saying, hey, look, this is a congressional delegation to the board. We have to take that seriously. And this shouldn't be yet another example of courts kind of overriding labor policy as created by the board. So she concurred in the judgment, but she dissented in part. And I think her warning slash kind of indictment of what the majority is saying, I think is kind of a really important kind of insight into what's generally happening across the board in labor law.
And before we move on, can you just give us 60 seconds on Muldrow, which I think was widely received as a good decision. And we aren't going to be talking about many of those today, so could be the bright spot.
Right. Well, Muldrow and Bissonnette, both unanimous. Bissonnette said, kind of expanded the realm of employees who were considered to be transportation workers, right? So the arbitration statute exempts transportation workers. So to the extent that lower circuits had said, well, transportation workers have to be in the transportation industry, the court said, a unanimous opinion said, no, anyone who's involved in transport, even if you're in the baking industry or the bakery industry, you know, you can still count as a transportation worker. Muldrow, another unanimous opinion, although with 3 concurrences in judgment essentially says, in order to find harm, it doesn't have to be significant harm when we're talking about employment discrimination at the workplace, right? So in terms of what you can bring a suit alleging that the employer discriminated against you under Title VII, you don't have to show a level of harm that rises to some sort of level of significance. This is pretty consistent with earlier cases like Burlington Northern, where the court has said, you know, we're not going to set up some arbitrary threshold of what harm is. We want that to be engaged in. The concurrences essentially say that they don't like the way that Justice Kagan framed the inquiry. They thought that her opinion was too ambiguous, and that the lower courts will be left, you know, without enough guidance. But I think part of the point of the majority opinion was not to allow these kind of artificial kind of levels of harm to be created by lower courts in kind of kicking out cases that they thought just weren't, you know, serious enough in terms of the harm.
Right. A compromise decision, essentially, from Justice Kagan. Thank you, Matthew. I next want to turn to Genevieve because Kathay holds in her hand the Trump cases, which I think many attendees are really going to be interested in. But this was actually an important term for the First Amendment as well. And I would love for you, Genevieve, to talk us through how the Supreme Court did or did not address the major free speech issues that reached its docket before we get to the all-consuming matter of whether Donald Trump now gets to be a king.
Okay, great. I'm glad not to have to answer that question. I can talk about the not quite as consequential, but still pretty significant questions about what the First Amendment looks like online.
Really crucial questions, yeah.
Yeah, especially if, I hope we're not, but if we all see the possibility of a Trump administration. We know in the past that that Trump, when he was president before, was no fan of free speech online. And so we could imagine whatever problems we see with the way in which the social media platforms are being regulated now potentially could get much, much worse and could be wielded very directly against progressives. So I do think, although this is somewhat less, and as we saw with these cases, right now, a less polarized part of the court's docket, it is very significant and perhaps only increasingly significant. Okay, so this is the term that the court really confronted the social media platforms and the meaning of the First Amendment online. It had decided a whole bunch of cases in the late 1990s, early 2000s, in the 1990s, what's often called the porn panic, where there was this concern that the internet, there were these studies that came out that reported that something like 80% of everything online was pornography. This was incorrect, but this was the sort of widely circulated figures at the time. And it led to a flurry of very repressive lawmaking by Congress, trying to prevent children from accessing indecent and obscene materials online. And at that period, this was a period of sort of tech utopia. Everyone was looking forward to, despite the anxieties about porn. This was a pre-social media era. The court very clearly and simply took a relatively libertarian stance and said, no, that's not okay. The First Amendment protects speech online in a case called Reno v. ACLU and in a subsequent set of cases. And for a while, it seemed like the question of how the First Amendment applies to the internet, and then when the social media platforms emerged to these new democratic speech forums, social media, was settled. It's just libertarian. We're not going to allow the government to regulate in very significant ways. But in the mid-2000s, I think around the time that Trump gets elected, all of this falls apart because there begins to be great anxiety, I think, on the left about the ways in which the rise of these large tech giants, the ways in which they were abusing their power, the failure at that time to moderate, the Cambridge Analytica scandal, this worry about the platforms getting rich off our data without providing any protection or information to consumers. This leads to significant ramping up on the platform's part of their content moderation, of their speech rules. And in return, and in response, a major conservative backlash, this very intense and ongoing, now I think we're entering like the eighth year of major conservative anxiety about anti-conservative bias online. An anxiety that I think all the studies have suggested is not a reflection of discrimination in application of the rules. So if anything, the platforms bend over backwards to treat, especially important and influential Republican politicians and conservatives with kid gloves, precisely because they're worried about retribution and being targeted as one of these West Coast elites. But the rules are rules of civility. The rules are designed to promote and foster a certain kind of speech environment. And I think in application, they do fall heavier on certain kinds of radical voices. And so this generated intense frustration, resistance, and ultimately political mobilization. And so this produced essentially, in my neck of the woods, a huge culture war about how to think about platform power and discrimination. And that I will have to say, to an ACS audience, has complicated political valences, because the left, it had always been the progressives and the realists who had said, we should really worry about private power and the ability of large private corporations to suppress and exclude socialists, communists, union activists from the important channels of mass communication. And what is really remarkable about the last 10 years is it has been the right that has taken up this really realist and progressive language about power and domination to justify what are, I think, laws that are aimed at wreaking retribution against the tech giants who the conservatives believe to be the architects of all things bad and in cahoots with the Biden administration, really, to suppress good old patriotic conservative speech. And so it was this complicated mess, the right, in particular, Justice Thomas and Justice Alito, sounding like Frankfurter and the early 20th century realists. It was bizarre. And then on the left, who knew what the left was? Jackson's views on the First Amendment were not at all clear. And then we had Kavanaugh, who has been very strongly sort of market-centered view of the First Amendment. We had a sort of a very complicated brew. And I think leading into this term, no one knew how the court would handle it. And the court, I think, for many years has not taken up a significant social media First Amendment case because it didn't know what it was going to do. And so, but this term, it took 5 cases. And the cases fall into 3 buckets. There's one case that involves the question about whether or not government officials, usually local government officials, can block or mute users who criticize them on their Facebook page or their Twitter feed. Another bucket of cases involves the rules that surround government jawboning, when the government colludes with, coerces, pressures, uses informal means to get the private social media platforms to kick speakers off or to deprioritize their speech. And then the last bucket, I think, was the most culture warsy, although all of them are to some degree, and Trump is involved in all these cases in some way. The last bucket involved the Texas and Florida social media laws that impose some amount of non-discrimination obligations on the large social media platforms in the name of combating anti-conservative bias. And really, in order to ensure that if Trump runs again, this was when they were enacted, he could not be kicked off the social media platforms. So that was it was all a consequence of the trauma, I think, that conservatives experienced when Trump was kicked off Twitter, Facebook, all the other major platforms after the Capitol insurrection or the invasion of the Capitol. So no one knew where the court would go because the politics here was super weird. The conservatives were sounding like progressives and realists. The liberals were not really talking. The middle of the court was libertarian. No one knew what would happen. And to some degree, we still don't really know what the ultimate conclusion is going to be because the court in many of these cases decided not to decide or kick the can down the road because of the difficulty of these cases. And so I guess but we know several things. So we know one, which is that the Fifth Circuit, which had been kind of the judicial avant-garde, I guess the doctrinal avant-garde.
That's a very diplomatic way of putting it. I appreciate
it really is extraordinary what the Fifth Circuit has been doing as a kind of inventor, entrepreneur of new ways of viewing the doctrine in all areas, but also in the First Amendment. The court pretty significantly in several of these cases reprimanded the Fifth Circuit and said, look, we're not reinventing the entire fabric of First Amendment law. And so in some ways, I think, most surprisingly to me, but also very interestingly to me, Kagan's opinion in Moody v. Net Choice, which was the consolidated opinion written to deal with the Texas and the Florida laws. Kagan writes the majority. There are incredibly enough no dissents. This is one of the most contested culture warsy First Amendment cases that have come to the court. They managed to cobble together an opinion to which there are no dissents. There are concurrences in the judgment, so there are unhappy justices on the court, but there are no actual dissents. Kagan writes the majority and says, Fifth Circuit, you got it wrong. And then, I don't quite yet know how to make sense of this, re-articulates a highly libertarian conception of the First Amendment. She invokes as the central organizing principle of this decision the line from Buckley v. Vallejo, the campaign finance case, that is one of my least favorite lines in all of First Amendment law, which is that the principle that the speech of some in society can be suppressed in order to promote the speech of others is a concept that is wholly foreign to our law. Now that is, by the way, bananas, okay? The whole idea of one person, one vote is the idea that we're going to equalize expressive opportunity in important ways. And the line reflects this sort of very anti-campaign finance, anti-redistributive impulse in the First Amendment. So Kagan picking up a line that the majority wields in Citizens United to strike down laws restricting corporate spending seems to me an indication that the court, including the liberals on the court, is reaffirming what I've called a Lochnerian or a laissez-faire First Amendment, where we're not going to think about power inequalities and we're not going to allow the government to protect some speakers against the perhaps more powerful, expressive choices of other speakers like the platform owners. And so in that way, I think this was a terrible decision and progressives should be concerned about it. On the other hand, the Kagan is wielding this very libertarian First Amendment to make it more difficult for very motivated conservative legislatures like the legislatures in Texas or the legislatures in Florida to enact laws that are going to undermine the ability of the platforms to moderate. And so there are some progressives who have celebrated the decision for pushing back against the conservative assault on the social media platforms. I think it's very unclear and complicated how we should think about it. I think it is part of an ongoing shift in the First Amendment and more broadly in the political valence of different kinds of attitudes. I was thinking about it actually on this panel when I was listening to Sabeel talk about the administrative law cases and about the sort of anxiety that by, expanding statutes of limitations, you're going to open up the possibility for there to be, motivated courts to reach deregulatory outcomes. But I was thinking I completely hear you, I understand that, but that, usually it's progressives who want to open the courtroom doors, who want to expand statute of limitations. And yet in a context where we have Trump judges and we have very motivated courts, these valences flip. Similarly, in the First Amendment context with the Moody case, traditionally, as I said, it has been the liberals and the progressives, and I count myself among them, who have been really worried about the abuse of private power. And now it is the liberals in the court who are articulating a view of the First Amendment where we don't take that into account, where we just say, we're worried about the government. We're not worried about private power. That's just the way it is.
Totally. I do think it's worth noting that Justice Jackson, and you mentioned this earlier, did not join all of the portion of Kagan's opinion where she favorably cites Buckley and where she fully and forcefully puts forth this libertarian view of the First Amendment. So it seems that perhaps Justice Jackson is not on board in the way that Justice Sotomayor and Justice Kagan are with extending this sort of libertarian project to the internet and shielding social media companies from the regulation, even if it's a kind of regulation like Texas and Florida are imposing that progressives dislike because it's all sort of centered around Trump and pro-Trump speech.
Agreed 100%. I thought her decision to join and not join was very significant, but I also thought it was significant that no one else joins her opinion. She doesn't find common cause with Thomas and Gorsuch and Alito. Before these opinions were handed down, there was some speculation, are we going to find strange pairings because members of the court are going to be getting coalitions that are going to advance particular views, an anti-laissez-faire First Amendment view or a pro-regulatory First Amendment, whatever it may be. And that didn't happen. As far as we can tell, Jackson is not sympathetic at all. There's too much daylight between whatever her view of the First Amendment, which I agree seems to be not as laissez-faire, and the Alito and Thomas and Gorsuch. So we'll see. I mean, again, this case, like many others this term, the Moody case leaves a lot open. So perhaps in order to get the votes of someone like Jackson, the majority opinion, even while articulating this kind of very deregulatory, laissez-faire, let's protect platform power view of the First Amendment, also doesn't overturn the laws. Fascinating enough, says, well, we have to remand to the lower courts to figure out whether there are possible applications that are constitutional. And so it does leave open the possibility, which I'm surprised by actually, that there could be some social media functions or some services that can be subject constitutionally to non-discrimination laws, even perhaps to common carry regulations, which I know Sabila and others has suggested might be a good way of protecting the rights of little guys online and might be a way of thinking about equalizing power inequalities. And so the court has not completely put that off the table, but it has put it off the table for the most important social media services, the Facebook feed, the Twitter feed, YouTube. And so it's unclear exactly what that means going further, but I was very distressed to see the Buckley citation by Kagan. Can I say one more thing about the social media cases? I know everyone's
absolutely. If you could just sort of close the loop on the Murthy case, the jawboning case too.
Yeah.
And I know that you would want to talk about NRA versus Bulo, but I would love to just get the Trump cases on the table after that, if it's okay.
For sure. Yeah, I actually just wanted to say just a quick word about jawboning, because I just tried to get everyone in the audience to be a little bit scared about platform regulation, because I don't know if it's going anywhere good. But the jawboning case is actually the scariest to me. So Murthy involves a crazy, terribly lawyered, terribly argued jawboning case involving this sort of conspiracy set of grand allegations that all members of the federal government, the Biden White House aides, the CDC, the FBI, private research organizations, all of them had collaborated and conspired to get the private social media platforms to kick conservative voices, anti-vaxxers, election deniers off the platforms. And so this was sort of a right-wing fever dream. And Fifth Circuit had bought it hook, line, and sinker, that this is completely unconstitutional. I think the Fifth Circuit said like greatest assault on First Amendment rights in the history. It was crazy, overheated. And the good news is that the Supreme Court says no. It says plaintiffs don't have standing. This is there's no constitutional violation here. And I think given the facts of the case, that is a correct holding. The worry is that the standing rule it articulates in this case is very rigid and very restrictive. And the problem is that in cases where the government puts pressure on social media platforms to kick speakers off the platforms, those speakers often won't know all the facts, because it's the platform that is getting the pressure from the government, but the platform's not going to speak because it either is going to go along with it, or it's not going to want to confess all this behind the scenes business. And so it is often very hard for jawboning plaintiffs to get standing in court. And so the Murthy decision, while I agree with the holding, the breadth of the standing rule that it articulates is going to make it, I think, in the future, very difficult for plaintiffs to get into court to challenge the government's actions when it does put pressure on platforms to kick them off. And I think Trump is going to love jawboning. The Libertarian First Amendment is going to prevent him from being able to directly regulate the social media platforms. And so he is going to use all of the informal powers at his disposal, which as the head of the federal government are a lot, to put as much pressure as he can on the social media platforms to get you and me kicked off social media if we say anything that is contrary to his policy agenda. And my worry is that Murthy makes it easier for him to do that without any judicial pushback.
Thank you. On that deeply upsetting note, I want to give attendees the second CLE code. Important information. That code is PICNIC, PICNIC. Again, that code is PICNIC. And now, totally unrelated to picnic, the farthest thing from a picnic you can imagine, actually, we're going to turn to the Trump cases. And Kathay, if you could lead us off, I think the trio of Trump cases, Anderson, the immunity case, and then the Fisher case, which of course bears on the Trump prosecution.
Right. And Mark, I don't know if there will be time to talk about the redistricting case, but that was also—
You're welcome to throw that in.
I'll try to squeeze it in. All right. So how do we even begin? Other than to say, I think that the link between the Trump cases and the redistricting case is a kind of political determinism. We will swing whichever way we need to, twist the law, however we need to, bend precedent and interpretation of the Constitution in order to get to the political outcome that we want. And unfortunately, in most of these cases, the votes fall down in a partisan way along the ways that we might assume that they would based on the appointments. Not always, but more than we would like. So let's start with Trump v. Anderson. So this is a case that originated out of Colorado. It was about the insurrection and whether the 14th Amendment, Section 3 prevents somebody who has committed insurrection from being able to hold office, federal office specifically. And the Colorado court, this is a fact that is oftentimes not reminded or talked about, actually had 5 days of hearing, heard testimony from experts, as well as an officer who was in the Capitol at the time that the January 6th insurrection happened, talked about the kind of violence, the way, the direction of that violence that happened from the moment that words were spoken by candidate Trump, directing people to go to the Capitol, and then what ensued afterwards. And in particular, also noting that President Trump had been appealed to by a number of different people to call it off, to bring in protection for the Capitol, and repeatedly refused to take that kind of action that one would expect from the president if they actually cared about the country as a whole and not just their own pursuit of winning an election. And so in hearing all of that evidence, the Colorado court said that in fact it found evidence for insurrection, and as a result was going to remove Trump from the ballot. In a show of remarkable speed, the Supreme Court accepted the case for oral arguments, and then in 4 weeks after oral arguments, issued a decision saying that, in fact, Colorado's Supreme Court had acted without authority to remove someone from the ballot. And in fact, that decision really rested solely in the hands of Congress. So moving forward, and I bring up the timing because with the next case, Trump versus United States, the amicus brief that Common Cause filed was to raise that whatever else the Supreme Court might do, it should consider that in cases where they have considered whether or not the election of a president should move forward, that they have acted with, or I guess in cases that involved presidential power generally, they have moved with a great deal of speed. And we pointed out that, hey, by the way, in Anderson, you only took 4 weeks. But if you want to go back into history, in Nixon's case, 2 weeks after oral argument, the court issued its decision. In Bush v. Gore, it was 1 day. So it should be able to make a decision fairly quickly, because we thought that the question at hand, whether or not the president should be afforded immunity from criminal prosecution, was a relatively easy one, and the answer was no. Or if you had to decide on a sliding scale, that you might come up with a judgment on what types of acts could be immune, but it would not be an absolute immunity. Interestingly, the court took a full 9 weeks, plus some days, to make that decision. And interesting because in taking as long as it possibly could, waiting until the very last day of an extended court term to make that decision, it essentially made impossible for the trial, the underlying case, to move forward to a trial in time for people to know what the outcome of that trial would be by the November election. That doesn't necessarily mean that a trial couldn't happen just after the election. And certainly I think one of the biggest fears is now that the decision has come out, if a trial does not happen before January 20th, Inauguration Day, what might happen if the outcome is that a particular president decides that they want to remove from the Department of Justice any ability to prosecute them further, remove the power of the special counsel, and then essentially undermine any kind of case from moving forward. So let's back up and see what the Supreme Court actually decided. I think by now, I don't need to say it because it feels like if you didn't know, then you must have been under a rock for the last several weeks. But the Supreme Court essentially said, when it comes to official acts, there is actually absolute immunity. Official acts that have been defined by the US Constitution. There is an additional, yes.
Just before we even move on to the taxonomy, do you want to point us toward where the Constitution says that? Point us towards some text or any provision that says absolute immunity?
Curiously, a textual, a historical, and against precedent, a group of Supreme Court justices who believe in textualism when it serves them could find no text to serve this particular outcome. And so that's why I say
that didn't stop them.
This is outcome determinative. There's an outer periphery of official acts that they would apply a test to decide whether or not those acts could be prosecuted or if there would be immunity. And then there would be an outer periphery of things that are non-official acts or acts that are taken under a personal capacity that would be that could be prosecuted. So there would be no immunity. I'm just going to open this up as an equal opportunity discussion amongst all of the scholars in the room who can bring history, precedent, and textualism into play here to have the conversation about the legitimacy of this decision. What I will say is it's important, if you want to look at what our potential parade of horribles would be, to read the dissent, which then points out all of the things that are official acts that are squarely authorized by the US Constitution, regardless of whether there was corrupt intent or otherwise unconstitutional motives or behavior, that it would serve that person to be absolutely immune from prosecution. And so in that list, and I'm not even going to make it up, the dissent talks about what happens if Navy SEALs, Team 6, are sent to assassinate a political rival. You're allowed to order the Navy SEALs. So therefore, and you're not even able to investigate whether or not the underlying motives violate any kind of constitutional restrictions or congressional mandate. You could use the Department of Justice to investigate a rival to investigate a rival. And I'm hearkening back to, additionally, the ability to hire, but also to dismiss special prosecutors. So we know in the Nixon years that the dismissal of the special prosecutor, Archibald Cox, is what led to the Saturday Night Massacre, or the attempt to, and ultimately what led to court finding that the dismissal was illegal and set off the set of hearings that led to the impeachment of Nixon. What's interesting there is that because the hiring or firing of a special prosecutor would fall within the powers that are allocated by the Constitution, it is possible that all of those events might not be protected by, they might be subject to the absolute immunity or fall within the periphery of official acts. Ordering a military to stage a coup or to hold on to power, also okay. And then I think the thing that sort of troubles me most is the ability to grant pardons based on bribes from major donors or people who have appealed because they have been prosecuted for the January 6th insurrection, but they're now potentially protected irregardless of what the motives might be, because those, again, are powers that are granted by the US Constitution. All of those, I think, go far beyond what we thought the Supreme Court would do. And Even in the balancing test, I think, the Supreme Court could have stopped short and just said that the balancing test applies to all official acts, and we're just going to go through that, but instead decided to carve out a special group of actions that would allow a president to essentially act as king, as long as they were exercising enumerated constitutional powers. What does that call on us to do? It calls on us to think very seriously about whether it's time for a constitutional amendment, and frankly, to create checks and balances, because we know our Supreme Court at this point, with this particular composition, will not. And depending on what the congressional makeup is coming out of this upcoming elections, they also may not hold the president accountable through their powers of impeachment. So we are in a very dire situation where I think it's not an understatement to say that we're at the precipice of whether this democracy continues to exist, or if we descend into a place where the United States becomes under the power and control of a tyrant or a king. Lastly, I'll say that in the Fisher case, so this was a case that is about the prosecution of people who had engaged in the January 6th insurrection. It really centered around, I think, a smallish issue. And it is important to remember that many of the people who have been prosecuted were prosecuted under multiple different violations of criminal law, this being only one of them. But Sarbanes-Oxley, 18 USC section 1512 has a provision that says that a person cannot impair the ability or integrity of the use of official proceedings by essentially tampering with records or documents that are used in that official proceedings. And there's an additional clause that says, and other. And the question was whether the and other anticipated the possibility that people might want to interrupt the official electoral count that was going on in Congress. So that's the proceeding, by storming the Capitol and trying to prevent that from happening. I think the reality that the dissent points out is nobody would have anticipated that that was possible. I think everybody was, when Sarbanes-Oxley was first passed, thinking about Enron. But the other piece of it is that we write laws in order to anticipate not only the current situation, but also future situations. I don't think that anybody would have thought that destruction of documents when it comes to a planned coup would be permissible. So even though planned coup was not in the stated in the law, I think that's one of the things that, we probably would have anticipated. Congress could agree that that's the kind of official proceeding that should have been covered. Be that as it may, the majority decided that that section should not be interpreted so broadly. And so to the extent that people who had been involved in the January 6th insurrection had been charged with that particular charge, that charge now falls away. Permission to talk about the redistricting cases, there is a relation. So the case that came down this term came in on May 23rd. And it's significant because it's also the same week that the New York Times released its discovery that Justice Alito had been flying an upside down flag outside of his house, and certainly raises a lot of questions about whether, and then followed shortly by the lone pine tree flag that is associated with the January 6th insurrection. It certainly raised a lot of questions about whether Justice Alito should have recused himself from any of these decisions. But in the other Anderson case, Anderson versus South Carolina Conference of the NAACP in redistricting, this decision came down at the same time as the flag case was revealed, or the instance of flag flying was revealed. And the underlying facts are that there was a district in South Carolina District 1, that has traditionally been drawn in a way that was centered on Charleston, largely held whole the county of Charleston as well as the city of Charleston. And in 2020, after the census, was found to be underpopulated. So some population needs to be moved into this district in order to create equal population. The legislature decides, not only, should mention that this district has a heavily African-American population, and the legislature decides that it wants to cap the African-American population at a certain percentage. So in adding people in to that district, it also needs to remove enough African-Americans to keep it at a certain threshold. That's what the plaintiffs are alleging. This district also happens to be a very swing district. So swinging between Democrats and Republicans in one decade, but at the end of the decade it is held by Nancy Mace, a significant name to note in sort of a lot of the shenanigans related to January 6th and, you know, a lot of the other investigations. Nancy Mace is holding on to it by a bare thread. And so the question is whether the legislature is redrawing these lines to protect Nancy Mace and give her more Republicans, or if they are doing so by essentially tagging African Americans, removing just enough in order to give her a safe seat. If there is mixed motive, the Supreme Court says, now plaintiffs, you have the additional burden of showing that, yes, there might have been a racial motive, but that you can actually draw a district that gives Nancy Mace the protection that she needs from a partisan challenger of a different party while increasing or holding on to that African-American population. This is a standard that has never existed before. They also say that all that circumstantial evidence of racial motive is insufficient. We need direct evidence. Again, a new standard under the 14th Amendment for finding racial gerrymandering. This is a roadblock that essentially started with a roadblock in Common Cause v. Rucho, without getting into that into greater detail, and became a total nuclear bomb that blew up the entire road and said, sorry, if you want to take the 14th Amendment to challenge racial gerrymanders, and if you're a Black plaintiff, give it up, because a legislature can always claim that it was a partisan gerrymander, and that is entirely okay. The upshot is that in legislatures, it's giving a green light to state legislatures around the country that have the power to draw districts, and that's not all states, but in those states where there are state legislatures, to essentially engage in a scorch and burn policy if they want to, when we're redrawing the lines for 2030. And unfortunately, where I think there has been some ability in some states to craft redistricting maps that try to take into account the traditional redistricting factors, like holding a city together, holding a county together, thinking about, you know, equal population, all the other traditional redistricting factors. This case essentially says there's one traditional redistricting factor, the unstated one, that is more important than all of those. And that is, it is okay for a state legislature to engage in partisan gerrymandering, that is favoring their own party to protect incumbents over all other traditional redistricting factors. And the hill is very, very high to be able to show that it was for any other reason that might violate state constitution or U.S. constitutional protections. So that's the outcome of Anderson. It's a bleak one. And I think 2030, if we don't see other kinds of reforms, we're going to see some real efforts to try to stack and pack, regardless of what the impact is going to be on minority populations.
So I'd love to bring some other panelists into this discussion, particularly the discussion of presidential immunity. And Sabeel, you were talking about the court disempowering agencies, and I find it striking that at the same time that the court is disempowering agencies, which are part of the executive branch, it is turbocharging the powers of the president himself. What do you make of that sort of dichotomy, the split screen that we're seeing there?
Yeah, I'm so glad you asked that, Mark, because I think it's actually really important to understanding what is actually going on with this court and with the vision of political power that I think, especially the 6-3 majority, is advancing. I see them as very much connected to one another, because in a lot of ways, it's about dismantling the institutions of democracy on either end of the equation. On the upstream end, it's really removing a lot of those protections for fair elections and for an accountable executive, what Kathay was just talking about. That's sort of choking off democracy at the front end. Now, if you somehow get through all of that gauntlet and you elect a government that then does things that people want, like debt cancellation, or like protecting workers from excessive heat, or regulating on climate, then they come at you with all the deregulatory doctrines, chipping away at agency powers that are actually trying to do the substantive things that democratic publics are demanding government to do. So from my perspective, it's really part of the same playbook, which is concentrating power either in a singular authoritarian, singular president, or in those private powers, corporations, private individuals who can now discriminate without the kind of civil rights protections that haven't come up as much this term, but a big part of previous terms, right? And so I think the through line for me is these are all attacks on democracy one way or another.
Do other panelists have thoughts on that case or that sort of broader theme? Then in that case, I'd like to sort of draw out something else that I think was implicit in actually several of the cases we discussed, which was the Fifth Circuit, which Genevieve, you described as being avant-garde. And Greer, I'd like to start with you. The Alliance for Hippocratic Medicine case you mentioned was a Fifth Circuit case. Can you talk about sort of broadly how the court addressed or dealt with or treated the Fifth Circuit in that case? And maybe we can bring in one other decision that we didn't get a chance to talk about today, but that's Rahimi, which is a case in which the Fifth Circuit held that people under a restraining order for domestic violence have a Second Amendment right to possess their guns. The Supreme Court reversed the Fifth Circuit in an 8-1 decision there. We can just add that to the pile of decisions like Alliance for Hippocratic Medicine, like Net Choice, where the court ended up reversing the Fifth Circuit. I mean, what do you make of how this push and pull is having an effect on the law between the Fifth Circuit and the Supreme Court, Greer?
Well, I think for me, it's the Fifth Circuit is hugely important, but it also has to do with these, unitary judge districts, right, where you can make sure that you get Kaczmarek whenever you file a lawsuit. To me, that is kind of like the big story of the Alliance case, right? This case. Yeah. Which functioned to basically, meritless, not only on substance, but procedure, which kind of made it all the way to the Supreme Court. And you have a conservative movement that has kind of created a system where if you could file in this particular area, you can kind of have that go exactly your way. And so basically, if you have Kaczmarek as your district court judge, you know that the most kind of independent court that's going to hear your case is the Supreme Court, right? This ultra conservative court. So, the Fifth Circuit was slightly better than Kaczmarek, but it was still willing to engage in a kind of like really remake standing law to try to allow Alliance to kind of get its claims in. You saw Judge Ho in the Fifth Circuit also kind of say, we haven't talked about Comstock, but at one point we might want to talk about Comstock, right? Say Comstock.
Go ahead, talk about Comstock.
So for those of you who don't know, there is an 1873 law still on the books that hasn't been enforced since the 1930s that the anti-abortion movement is arguing bans abortion nationwide, right? And this case that the Comstock Act came up in the Alliance case, it's a huge issue if Trump wins, because if the anti-abortion movement gets its way and the courts adopt their interpretation of Comstock, they have the possibility they're going to try to create a national abortion ban. Like, that, right? They don't have to pass a law. They think they have one. The Fifth Circuit, Judge Ho says, yes, that's fine. 2 justices on the Supreme Court seem to also say that was fine with them.
Thomas and Alito during arguments you're referring
Yes.
to. Yeah,
exactly. Yes, they didn't say it in the opinion, right? They just talked about it in oral argument. So yeah, and honestly, the EMTALA case, right? The court granted cert for the Idaho version of this case, but I mentioned this before, right? The Fifth Circuit had ruled on EMTALA as well. So very much you see the Fifth Circuit being a huge player and all of these cases, these kind of culture war cases, and really making it so that they can be as they shift the Overton window, right? They have the most aggressive, insane kind of opinions, and then the Supreme Court looks moderate by comparison. And
like specifically on that, Sabeel, if I could just go back to you really quickly, one of the other cases we didn't talk about was the CFPB decision, where the Fifth Circuit purported to strike down the entire CFPB. The Supreme Court comes in by a 7-2 vote, says no, the CFPB cannot be judicially invalidated. It's funded constitutionally. The money is appropriated constitutionally. I'm curious what you made of the Supreme Court in that decision. A very rational opinion by Clarence Thomas, of all people, essentially scolding the Fifth Circuit for going too far too fast on that.
Yeah, I think it's a great connection to what Greer was just talking about, because it has a little bit of this, this court in general, I think is very good at issuing some decisions that create a patina of legitimacy on other decisions, right? Mm-hmm. So great for Thomas to give a 7-2 decision to stave off one set of crazy things coming out of the Fifth Circuit, but that just, if anything, like buys cover for all the other stuff. So like, now good luck to our amazing friends at the CFPB who are doing incredibly important work. Them, the FTC, others are now going to have to run through the gauntlet of Loper Bright and Jarchesi and Corner Post and everything we just talked about. Not to mention the major questions doctrine, which we haven't talked about, but is still very much there, right? So I think it's a little bit of like giving a little to take away everything else. It's a hollow victory in my view.
And before we move on from this topic, Genevieve, I wanted to turn back to you. You mentioned the Fifth Circuit sort of bought this conspiracy theory that the plaintiffs were peddling hook, line, and sinker. 3 justices ended up embracing that. What do you make of the kind of synergy in Justice Alito's dissent with the Fifth Circuit? And what does that tell us about how essentially a kind of made up grievance here in the Murthy case can spiral into a decision that not only prevails at the Fifth Circuit, but wins a trio of votes on the Supreme Court?
Well, yeah, it's complicated, especially when thinking in light of the Chevron decision, where the court is so clear that, we are really empowering courts because we trust them on matters of statutory interpretation. Courts are so good at figuring out what the best understanding of the law is, and they're the whole point of the trial process is you get to truth and and the courts are supposed to be the one arena in our system, or at least that this court recognizes, because it doesn't like the administrative state, where there is some kind of adversarial process that is supposed to get us closer to truth. And yet what we see with the Fifth Circuit, I think dramatically in Murthy, but in almost all of the cases we've been talking about, is playing very fast and loose with the facts. At the same time, just as Sabeel was suggesting, the court this term, I think, took the opportunity to push back against this in order to shore up its legitimacy. And so what we see is, on the one hand, the court affirming again the importance of being very careful and very sober and being careful with the facts. And as you say, 3 members of the court not signing on in some, to the judgment, but not buying that at all. And there's subterranean tension on the court, I think, between the various parts. Although, I guess to my mind, just thinking politically, it is interesting, at least in the First Amendment cases, that there is not common cause being made. And I think this was a theme throughout the court, that Barrett is not playing so nicely with the more hardcore conservative justices. And Roberts sometimes, in the immunity decision, we see that he can go full bore, and in other decisions he resisted. And so I do think it's complicated when we think about the politics of the court going forward. But in general, I just don't think consistency was a great element of this term's cases. Like, just thinking about the really rich conversation about all the different cases. Sometimes the court seems to be opening up the courtroom doors. Like, it wants those who want to challenge administrative regulations to have an easier way to get into court. And then in some cases, it's closing the courtroom doors and articulating very restrictive conceptions of standing. So I think that it's a sort of a very complex if we just think about the procedural decisions this term, which I think are very significant, standing played a huge role, not only in the First Amendment cases, but in lots of the other cases. A lot of the procedural mechanisms seem very significant. The court seems to be trying to have its cake and eat it too.
I want to turn to the Q&As and draw out a few questions. One that caught my eye is from Liz Walsh. And Matthew, I think this would be good for you in particular, because Liz asked, how should future lawyers arguing at SCOTUS change their strategies to account for SCOTUS's ahistorical and outcome determinative stance? Great description, by the way. Sounds like a really hard job to take on. You know, I asked this of you, Matthew, because two of your cases that you mentioned, Muldrow and Bissonnette, you know, they were small-ish cases, but they were also unanimous victories for labor. What do you think is the magic sauce there, aside from having a really great lawyer, that can sort of snatch a victory from a court that seems extremely hostile toward progressive interests?
Well, if I had the magic bullet, I would be hearing it more widely, certainly. I think it's really interesting, just in terms of how we approach these cases, because on the one hand, you see progressives wanting to sound the alarm bells and saying, oh my gosh, look what can happen. This is terrible. On the other hand, if you're an actual jurist or a litigator, you kind of want to say, well, you didn't go that far in that case. And, you know, you actually are kind of, you know, you want to kind of make the justices feel like, well, you know, you all are reasonable people and we can see why you did that. And that, I think the Starbucks case is a really interesting example of that, because I think the board attorney in some ways was trying really hard to assert a very strong vision of board authority. And it's one that I agree with, but I think it was clear pretty quickly that only Justice Jackson was willing to ride along with that level of authority. And even Justice Kagan seemed to have some skepticism about it. In the face of a statute that is often interpreted with common law kind of backgrounds. Again, maybe not the best way of interpreting a labor statute that was designed to like really kind of change a lot of economic principles in play, but at the same time, those battles have been fought and lost long ago. So I think that there is still some play in the court about making incrementalist, you know, kind of careful, and obviously hearkening to the statute. We saw in the Bostock decision, you know, Justice Gorsuch saying, well, this is what the statute says. So to the extent you can be textualist or originalist, right, there are folks making certain originalism claims that can back up, you know. Now, again, that's not to say, you know, again, I think the Trump case, as Kathay was explaining, like originalism, textualism, you know, looking to the constitutional provisions, where are they? But I think that would be, I mean, at least that would be my playbook.
Turning back, Kathay, to what you were talking about, we have a question from Jim Coffett. What is the basis for immunity? Is it an implied basis in Article 2? And then we have two questions from Jan Goldberg that I think dovetail with that. Jan asks, well, doesn't Article 2 list official acts? Does that mean that since those acts are listed, that they are implicitly sort of laden with an immunity from criminal prosecution if the president engages in them? Do you want to respond to that? You're on mute.
First one to violate that. There may be scholars here who are on this call who actually might have more insight into this. What I'll say is that a pure textualist reading, and this is coming from conservative scholars as well as those who fall into the liberal camp, would say there is no connection between providing absolute immunity for things that are official acts just because they're listed in the U.S. Constitution. Period.
Right.
They wanted it to be explicit. They could have said, and these official acts shall be protected from criminal prosecution. They did not. So the only way that you get there is by saying a notion of separation of powers, that the president should be able to act boldly and fearlessly, you know, and that's not written into our U.S. Constitution. That is Justice Alito's notion of what the president should be, and certain people's notions of what the president should be. It is entirely atextual.
We have a great question that follows up on that, asking for the reaction from panelists that the Chief Justice's response to Sotomayor's impassioned dissent in that case that you mentioned, Kathay, that the response was essentially to hush, to stop being so hysterical. And I am just sort of curious about the broader dynamic of the court that gestures toward. You know, my colleague Dial Lithwick wrote a great piece that the Chief Justice was engaging in a very kind of gendered rhetoric there, telling the three women liberal justices to just be quiet because Daddy Chief Justice is talking. I was curious if anybody wants to reflect on the way that the men, and especially the chief, sort of conducted themselves this term.
Well, sorry.
Yeah,
I would
please.
just say, I mean, with the EMTALA case in particular,
Yes.
there was a very important gender disparity in oral argument, where you saw particularly Justice Barrett really kind of, you saw her like a little bit flinch at what, you know, saying that EMTALA doesn't apply could lead to, which was that women were being literally airlifted regularly out of Idaho because of the medical complications that we're facing in pregnancy. And you could almost see that, like, how she was seeing that through the lens of someone who's been pregnant many times before, and understands that pregnancy can be complicated in a way that the men only wanted to talk about the spending power of the, you know, like how the spending power impacts preemption. And so, you know, kind of just like the embodied experience of pregnancy was very, very palpable in that oral argument, and how gender played there, I thought was pretty on display.
Really interesting. Anyone else want to contribute?
I'm just going to add the layer of both gender and also race. And I think that this kind of notion that, like, I only see race when it's white grievance, but I don't want to see race when it's like a bunch of people who are in Charleston complaining about how their city's been cut up, and how they've been deprived of the right to vote. And I don't want to see gender when it disagrees with me. And it sort of fits with this, I think, you know, harkening back a couple centuries back to the notion of what our dear absolute leader might look like. It just this very backwards notion of what the presidency should be. I don't know if our Supreme Court has 100% bought into the idea that if there is not a Trump presidency, how they're going to feel about immunity granted to the office of the president in the future. I unfortunately think that, or maybe fortunately, that what they're saying right now could be cabined to how they're feeling about Donald Trump, and that they might just find other ways to wiggle out of granting absolute immunity in the future.
It's like a Bush v. Gore style one-off for this
Bush v.
particular
Gore
situation.
style one-off, yeah, and let's not talk about that anymore. And the only thing that I can say about the dismissiveness is, if in quiet conversations in chambers, the conversation really was, look, we're going to issue this one-off, and we're just never going to talk about it again. So stop bringing up all the other hypotheticals, even though they are very real, because when future cases come to us, future cases will come to us. It's simultaneously dismissive and narrow-minded and outcome determinative, and a very sad reflection on where our Supreme Court is today.
Yes, sad reflection seems to be a good capstone for much of this panel. And before we finish, I just want to toss in one last question from the audience. This one from Chuck Taylor, and Sabeel, I'll direct it toward you and let you have the last word. The question asks, what is the future of critical agencies going to look like after Chevron's demise? Specifically, the FAA, the FDA, agencies within the Department of Defense. What's going to happen to the air that we breathe, the water that we drink, the drugs that we hope are safe and effective? And Greer, that's very much in your wheelhouse as well. So feel free to jump in. I mean, do we think that we're now going to see judges second guessing every decision by experts in the absence of deference? And what is that impact going to look like on the ground?
Yeah, I think it's pretty scary because I think what it's going to look like in practice is an even bigger open door for especially those most extremist judges to then take this opportunity invitation to selectively attack with, you know, the help of strategic litigants, those rules and agencies that they most dislike. And those, I think, will inevitably be those rules and agencies that protect women, protect workers, protect communities of color, you know, the kind of everyone who doesn't fit into the kind of ethno-nationalist patriarchal sort of notion of the people that I think you see on the in the kind of far right vision of democracy, or quote unquote democracy, right? And so I think it's pretty scary. I think the security state probably doesn't get the same kind of attention because, you know, if you notice in some of the other decisions we didn't talk about, court is very deferential to the surveillance state, to immigration enforcement, to the military apparatus, which is also scary, right? So I'll pause there. I know time is short, but I agree with others.
I mean, I think the only thing I'll say is that I think people have known that Chevron's, you know, on the chopping block for a long time, right? The Alliance case didn't raise it. So I think that as many people on this panel has said, I think in a lot of ways, the way the court will see kind of the future of Skidmore deference or whatever is left in the wake of Chevron will be influenced by the outcomes that they want to, what they want to get, which is, I think, probably the most terrifying thing. What does the FDA do under a Trump administration? I think it gets they get a lot of deference there. What does it look like in a future Biden administration? Way less confident that they'll get any deference.
Well, on that note, I'm going to close this out and say thank you so much to all of our many participants. And thank you especially to our amazing panelists for this lively and very edifying and only somewhat disturbing discussion of yet another momentous Supreme Court term. Thank you to everyone for being here.